On behalf of the Law Society of Western Australia, I'd like to open the 2020 Sir Ronald Wilson Lecture. I acknowledge the traditional owners of the land where I am. That's in Perth, Western Australia, and I'm standing on Whadjuk Noongar country. But I also acknowledge the traditional owners of the land where Pauline Wright will deliver the lecture. That's the lands of the Darkinjung people of the central coast of New South Wales. I offer my respects to elders past, present and emerging. I'm Nick Van Hattem, the President of the Law Society of Western Australia, and I welcome you to the 2020 Sir Ronald Wilson Lecture. 2020 has been a most unusual year. The impacts of the COVID pandemic have been felt far and wide, and they have impacted much of the Society's work, including in relation to the Law Society's education and community services. I'm speaking to you from the Old Courthouse Law Museum, where the Francis Burt Law Education Program is based. Some of its important functions are this museum, the mock trials competition, and court visits. In early March, the museum service and the mock trials were suspended for a time, and we did have some success with remote mock trials with some of the schools. Happily, since July, the mock trials competition has returned in person and this museum has reopened. The Education Centre also provides an opportunity for students and members of the public to observe trials. Regretfully, that's still suspended for the time being. We hope it can recommence soon. This lecture is named for Sir Ronald Wilson, and this is the first time it's ever been presented online. There'll also be a live webinar with a Q&A to follow tomorrow on 19 August. The lecture is named after Sir Ronald Wilson AC, who is a distinguished Western Australian judge, lawyer and social justice advocate. Sir Ronald was the first Western Australian to be appointed to the High Court. Among his many other achievements, it's most often the work he jointly led with Mick Dodson, the national inquiry into the forced removal of Aboriginal children from their families and communities, and the Bringing Them Home report that's most often cited. The 2020 Sir Ronald Wilson Lecture is entitled Kids in Jail, Raising the Age of Criminal Responsibility in Australia, and will be presented by Pauline Wright, the President of the Law Council of Australia. Pauline was the President of the New South Wales Council for Civil Liberties from 2018 to 2019, and also the President of the Law Society of New South Wales in 2017. Pauline was also a keen ocean swimmer, surf lifesaver, singer, actor, theatre producer, director and writer. It is my pleasure to welcome the presenter of the 2020 lecture, Pauline Wright.
Thank you very much. I'm Pauline Wright, the President of the Law Council of Australia. It's a pleasure to be here, and I thank the President of the Law Society of Western Australia, Nicholas Van Hattem, for inviting me to deliver the 2020 Sir Ronald Wilson Lecture. For those who don't know, the Law Council speaks on issues of national and international importance, federal law, and the operation of federal courts and tribunals. We represent approximately 65,000 Australian legal professionals through constituent bar associations and law societies, such as the Western Australian Law Society. Did you know that a child under 13 years of age cannot sign up for a Facebook account? A child under 12 can't board a plane unsupervised. And in some states, a child under 16 can't get their ears pierced without parental permission. And yet, here in Australia, children as young as 10 can be found to be criminally responsible, charged with a crime and kept in detention. During this lecture, I'll look at the legal framework of the age of criminal responsibility in Australia, why it's problematic, and the disproportionate rate of First Nations children in the legal system. And I'll ask the question, why do Australians lock up children? According to 2019 figures supplied by the Australian Institute of Health and Welfare, across the country there are around 600 children under the age of 14 in our prisons every year, some as young as 10 years old. More than half have not even been sentenced yet, but are still locked up pending trial. And these are some of the most vulnerable children in society. Many have been abused or neglected during their short lives. Many have cognitive impairments. And instead of being helped and given the therapeutic and rehabilitative support of society, they're being put into juvenile detention centres. The evidence is clear. Jailing children has a detrimental impact. It does not make our country safe, but exacerbates the problem. So let's look at the legal framework. Nothing is straightforward, thanks to the federated nature of Australia's political and legal system, where the states and territories have responsibility for their own juvenile justice systems. The main pieces of legislation regulating these systems are, in New South Wales, the Young Offenders Act 1997 and the Children Criminal Proceedings Act 1987. In Victoria, there's the Children, Youth and Families Act 2005. Queensland has the Youth Justice Act 1992. Western Australia and South Australia each have a Young Offenders Act 1994 and 1993 respectively. And both Tasmania and the Northern Territory have a Youth Justice Act 1997 and 2005, while the ACT has the Children and Young People Act 2008. Each statute provides a framework for dealing with children in contact with the criminal justice system, outlining, for example, procedures for how police respond to young people, how courts deal with young people, and how youth detention centres are operated. And of course, these major pieces of legislation interact with other pieces of legislation, including those that create or codify criminal offences in the first place, such as the New South Wales and ACT Crimes Acts, both from 1900, the ACT's Criminal Code Act 2002, the Queensland Criminal Code Act 1899, the Victorian Crimes Act 1958, the South Australian Criminal Law Consolidation Act of 1935, the Western Australian Criminal Code Compilation Act 1913, the Tasmanian Criminal Code Act of 1924, and the Northern Territory's Criminal Code Act of 1983. And of course, there's also the Crimes Act 1914, the Commonwealth Act, which deals with federal offences, including children. So if you're 10 in Australia, you're old enough to be a criminal. The type of government department responsible for the juvenile criminal justice system also varies across jurisdictions. In Western Australia, New South Wales, and since 2017, Victoria, the juvenile criminal justice system is administered by the same department responsible for adult offenders, the Department of Justice, Department of Communities and Justice, and Department of Justice and Community Safety, respectively. Queensland has a separate Department of Youth Justice. By contrast, in Tasmania, the Department of Health and Human Services manages the Ashley Youth Detention Centre, the state's only juvenile criminal justice centre, through its operational unit of Children and Youth Services. Similarly, in South Australia, the Department of Human Services, and in the ACT, the Community Services Directorate, which also manage child protection services, assume responsibility. In the Northern Territory, the infamous Dondale Youth Detention Centre and Alice Springs Youth Detention Centre, previously managed by the Department of Correctional Services, are now managed by the Youth Justice Division of the Territory Families. Despite this federalised framework, the minimum age of criminal responsibility is currently set at 10 years across all Australian federal, state and territory jurisdictions. What all of this means is that when a child reaches their 10th birthday, should they engage in offending behaviour, they may be at risk of being arrested, placed in handcuffs, transported in the back of a paddy wagon, held in a watch house, subjected to strip searches, interviewed by police, charged with criminal offences, made subject to bail conditions, held in custody, made to stand trial and incarcerated. So why are children as young as 10 locked up? There are some legitimate concerns held amongst some parts of the community that raising the criminal age of responsibility may undermine community safety. Community safety is, of course, a critical imperative, which deserves careful consideration. However, the best interests of the child and the best interests of the public may often align much more closely than is commonly recognised. The evidence strongly suggests that having a low minimum age of criminal responsibility of 10 years old does not work. It doesn't make our communities safer because it fails to prevent reoffending or to rehabilitate children. Instead, it's likely to entrench criminal responsibility or criminality, and it creates a cycle of disadvantage that heightens reoffending rates. Why is the current legal age problematic? The earlier a child comes into contact with the criminal justice system, the more prolonged their involvement will be, and the less positive their life choices will be. Children who come into contact with the criminal justice system are less likely to complete their education or find employment, and are 7 times more likely to become adult offenders. Professor Barry Goldson, a leading sociologist from the University of Liverpool in the United Kingdom, summarises this criminogenic pathway as follows. By introducing children to the youth justice system from the age of 10 years old, the normal or natural processes of growing out of crime are impeded. Labelling and negative social reaction is likely to lead to further offending. Education and employment prospects are undermined. The likelihood of entering penal custody increases. Children are damaged and harmed, and the public interest in respect of crime prevention and community safety is profoundly compromised. Child detention centres have often been described as universities of crime. The Australian government's Australian Institute of Criminology similarly warned that it is widely recognised that some criminal justice responses to offending, such as incarceration, are criminogenic. That is, they foster further criminality. It's accepted, for example, that prisons are universities of crime that enable offenders to learn more and better offending strategies and skills, and to create and maintain criminal networks. This may be particularly the case for juveniles who, due to their immaturity, and are especially susceptible to being influenced by their peers. Young people who are labelled criminal by the criminal justice system are likely to live up to this label and become career criminals rather than growing out of crime as would normally occur. The stigmatisation engendered by the criminal justice system therefore creates a self-fulfilling prophecy. Young people labelled criminals assume the identity of a criminal. Labelling and stigmatisation are widely considered to play a role in the formation of young people's offending trajectories, whether young people persist with or desist from crime. The Australian Bureau of Statistics has published data on the principal offences for which children between the ages of 10 and 14 were proceeded against by police. During the period from 1 July 2016 to 30 June 2017, statistics show that children between the ages of 10 and 14 tend to commit minor offences such as theft, break and enter, property damage and environmental pollution, and public order offences. It's extremely rare for young children to commit acts of violence. As stated by the Australian Institute of Criminology, certain types of offences, such as graffiti, vandalism, shoplifting, fare evasion, are committed disproportionately by young people. Conversely, very serious offences, such as homicide and sexual offences, are rarely perpetrated by juveniles. Juveniles are far more frequently apprehended by police in relation to offences against property than offences against the person. Instead of incarceration, we need alternative health and welfare-based responses to introduce policies and programs which maximise the chances of rehabilitating the child and upholding community safety in both the immediate and longer term. Early criminalisation may only serve to reinforce the child's pathway to committing even more serious offences which hurt or harm other community members. Raising the age to 14 would remove the need for courts to consider the confusing and complex common law doctrine of dolly incapax. No, it's not about dolls. Dolly Incapax states that anyone aged between 10 to 14 can't be held responsible for a crime unless the prosecution can demonstrate that they knew their behaviour was seriously wrong. The evidence relied upon by the prosecution must be strong and clear beyond all doubt or contradiction. We know that this doctrine is leading to inconsistencies in different jurisdictions, and it's difficult to use in a courtroom. For example, it's often difficult to determine whether a child knew that the relevant act was wrong, unless he or she states this during a police interview or in court. Therefore, to rebut the presumption, the prosecution has sometimes been permitted to lead highly prejudicial evidence that would ordinarily not be admissible. In these circumstances, the Australian Law Reform Commission has noted the doctrine may not protect children as intended, but instead be to their disadvantage. This doctrine is leading to children being held in custody for lengthy periods of time before the presumption can be led or tested in court, and the child acquitted. Removing the Dolly Incapax doctrine would be consistent with research-based evidence and medical consensus on brain development. So what is the neurological evidence? The evidence supports a higher age for criminal responsibility, as younger children are not sufficiently able to reflect before acting or comprehend the consequences of an offending action. Their brains, like their bodies, are experiencing significant growth and development so that they might not have the required capacity to be criminally responsible. The part of the brain that governs a child's reasoning, impulsivity, and consequential thinking is the most affected. In fact, specific regions of a child's brain responsible for higher functions such as planning, reasoning, judgment, and impulse control won't yet be developed and won't fully mature until they reach their 20s. Think about what you were like when you were age 10. I'm sure that your capacity to reason has been much matured since then. Maturity takes time, and we recognise that in almost every other facet of life. So let's put this in context again. You can't get a Facebook account until you're 13. You can't board a plane unsupervised until you're 12. And in some states, you can't get your ears pierced without parental permission until you're 16. You can't apply for a Medicare card until you're 15. And in Queensland, it's a criminal offence for a parent or guardian to leave a child under the age of 12 on their own. But in Australia, you can be locked up at the age of 10 years. And it costs a lot. On average, it costs roughly $531,000 per year to keep a single young person in juvenile detention. In the 2017-2018 year, youth detention involved a staggering total government spend in Australia of more than $509 million. Surely this money could be better spent on addressing the causes that lead children to commit crimes. We should be investing in prevention, early intervention, and programs that prevent future offending instead of doing the same old thing, a thing we know doesn't work. And prisoners have a reoffending rate of about 50%. That's adults, which is bad enough. But in children, it's far worse. In Victoria, it's 84%. And for 13 to 14-year-olds, that is, but for 10 to 12-year-olds in Victoria, the research shows that it's 86%. Childhood disadvantage is a real issue. It's incontrovertible that children in conflict with the law are significantly more likely to have experienced compounding forms of childhood adversity, and that childhood trauma of this kind interferes with a child's cognitive development. Such adversity might take the form of histories of neglect, physical and sexual abuse, family disruption, and significant economic, social, and medical disadvantage, including deprivation, poor educational experiences and supports, and inadequate medical care, all of which might contribute in turn to poor health, cognitive disabilities, learning difficulties, mental health issues, and substance misuse in children. A 2018 report by the Australian Institute of Health and Welfare found that 55% of young people in detention had also received child protection services, which was almost 10 times the rate for child protection services used for the general population. But let me be clear at this point. There is one community that is bearing the brunt of this policy. Aboriginal and Torres Strait Islander children, aged between 10 and 17, are 23 times more likely to be in detention than non-Indigenous children. And First Nations children are 17 times as likely as their non-Indigenous counterparts to have had contact with both the justice system and social services. Let me introduce you now to Duan Hussain, a young man from Arrente and Gawa country, Alice Springs. He's the star of a documentary, In My Blood It Runs. 10-year-old Duan is a child healer, a good hunter, and speaks 3 languages. Yet Duan is failing in school and facing increasing scrutiny from the police. He travels perilously close to juvenile detention, but his family fight to give him a strong Arrente education alongside his Western education. Duan travelled to Geneva and spoke to the United Nations, calling for an end to juvenile detention. In his address, he said, "I know lots of kids that have been locked up. Police is cruel to kids like us. They treat us like they treat their enemies. I'm cheeky, but no kid should be in jail. I want adults to stop being cruel to 10-year-old kids in jail." Let's have a look at a short clip from In My Blood It Runs. If you haven't seen this film, I really recommend that you do because it's pretty extraordinary. But here's a short clip.
Last night went to disco, had fun, went to Jacob and played football from down the creek, from the library, and from there cops came, chased us, put us in the paddy wagon. I came back here last night.
The Northern Territory's Police Commissioner has revealed plans to send a unit of camouflaged specialised police with military-grade weapons to patrol Alice Springs at night, and it's part of the Australian Government's National Counter-Terrorism Task Force. The announcement comes a week to the day since the Royal Commission delivered its report on youth detention and child protection systems in the Northern Territory.
I've been in a paddy wagon 4 times in a row. Every time I jump in a paddy wagon, I always start to feel funny. It's like you're in a limp box, can't get out.
Despite making adverse findings against youth justice staff and politicians, the Royal Commission hasn't recommended charges against those responsible.
I just found a way to get away. I'll be free.
So what does that say about Australia? Australia's laws are out of step with international human rights standards. We've ratified the United Nations Convention on the Rights of the Child. The Committee on the Rights of the Child, the body of independent experts that monitors the implementation of the convention, has twice called on Australia to raise its age of responsibility, first to 12 and more recently to 14. We're also out of step with the rest of the world. Elsewhere, the average age of detaining children is 12, and in Europe it rises to 14. Scandinavian countries such as Finland and Norway have embraced a different model for their children. That model is strongly focused on prevention and dealing with wrongful behaviour outside the courts and prisons. It means children under the age of 15 can be detained by police for a short time, but can't be remanded in custody. Germany has chosen to employ a social welfare response to address children under the age of 14. So what's the answer? The Law Council's position is that children under 14 should be held accountable for their actions, but they should not be held criminally responsible and incarcerated. We need to carefully consider the existing evidence and options available for rehabilitating children and keeping the community safe when a child does pose a genuine risk. There may be some limited role for the court system, but not the criminal court system in overseeing this process. For example, this process could be all handled through care proceedings, preferably in the family law courts, rather than criminal proceedings. But foremost, if we are to tackle this national shame, we need to listen to and support those who know the most about how the laws and policies affect their own communities. There's a campaign running called Raise the Age. It calls on all state and territories to raise the age of criminal responsibility to 14. On the 27th of July, there was a meeting of the Council of Attorneys General, including all the Attorneys General from across the country, and Christian Porter, the current federal AG. They included raising the age as an agenda item. It's known that the Federal Attorney General is not inclined to increase the age. He has said that he believes that there have been instances where it's appropriate to prosecute people who have been under the age of 14 for very serious offences, if it can be established that they had the requisite level of mental capacity to understand that the crime that was committed was both morally wrong and also contrary to the law. He said, "My own observations is the present system works relatively well and allows the flexibility for that to be shown, and in circumstances that are appropriate for there to be criminal responsibility attaching to very serious offences." While the Attorneys General made no decision to raise the age of criminal responsibility, they say that more work needs to be done to understand alternatives to imprisonment. This means that the conversation is far from over, and there is far more work to be done to advocate for raising the age. Thanks very much.
Thank you, Pauline, for an interesting and thought-provoking lecture. I think many people may have been disappointed to hear that the National Council of Attorneys General did not endorse a position to raise the age. But happily, work is being done in all jurisdictions. In Western Australia, the Department of Justice is developing a report on alternatives to custody for young people. I'd like to thank the exclusive sponsor of the 2020 Sir Ronald Wilson Lecture, Murdoch University, for their support of this important event. And I now encourage you all to take part in the live webinar. The Q&A will be with Pauline, Nicole Davis and myself tomorrow, 19 August from 4:30 p.m. to 5:15 p.m. Western Standard Time. Please forward any questions you'd like to put to Pauline or any of us on this topic to schools@lawsocietywa.asn.au. Also, there will, of course, be opportunities to put live questions to the panel. Ladies and gentlemen, that brings to a close the 2020 Sir Ronald Wilson Lecture. For those of you in Perth, please do consider visiting the Old Courthouse Law Museum. It's the oldest building in the city of Perth and Perth's first purpose-built courthouse. Thank you.